Thank you very much. I would like to give the floor to Giorgi and then we discuss further.
Hello, my name is Giorgi GOTSIRIDZE. I come from Georgia, working for Georgian Young Lawyers Association since 2009. I'm a lawyer for constitutional litigation, but since 2014 I've taken position of coordinator for the litigation on anti-discrimination issues. Let's get started with the adoption of anti-discrimination law in Georgia. As Leo said, this was the effect of visa liberalization process with the EU, and this dialogue started on June 2020. And the European Commission produced its first report on implementation of Visa Liberalization Plan on 11 November 2030, and according to this recommendation, according to this progress report, EU said that Georgia should adopt comprehensive anti-discrimination law. This was clearly mentioned in this report. So, and the inspiration was the UN Human Rights Committee recommendation. This was the inspiration that Georgia is in need of adopting such a law. And it was one of the preconditions of this visa liberalization plan. And how this the work of adoption of anti-discrimination law is was going on in Georgia. So, Ministry of Justice was entitled to draft anti-discrimination law, and according to the first version of this bill, it was envisaged that special equality protection inspector should be established, and this inspector should have the power to punish, to use these punitive measures against the alleged discriminator. So it must be a repressive body who should effectively implement the anti-discrimination law. It was the first draft that was elaborated by the Ministry of Justice. The process of drafting was very transparent and inclusive. This process was inclusive, and representatives of religious and ethnic minorities were involved in this process. So, Justice Minister took meeting with them, discusses the draft, and the minister gets remarks and noticed and criticism around this law, and it was very transparent process, and the representatives of religious and ethnic minorities, as well as the representative of other groups, for example, person with disabilities, LGBT rights activists, were very happy with this draft law as this new effective mechanism was about to create it. But this long process did not bring happy end, as the Minister of Justice sent this draft to the government of Georgia. According to the Georgian legislation, it is the government who should initiate the bill before the parliament. Ministry of Justice is not entitled to do so. And this law at the end of 2030 was sent to the government, and this transparent process was ended. So during 6 months, the preparation and government rewrote this anti-discrimination law. None of the members of NGOs or representatives of religious or ethnic minority were involved in this process. So drafting was going on behind the closed door without any public involvement. And in 2000, on the April 2014, this bill was initiated before the parliament. And in this case, we get to know what this bill was about. And this was totally rewritten bill. And according to the new bill that was initiated by the government, it is existing public defender or ombudsman responsible for implementing this anti-discrimination law. So the institution of equality protection inspector was erased out of the law. And public defender, if he finds the act of discrimination, is entitled to issue non-binding recommendations rather than to resort punitive fines or financial repercussion upon the discriminator. So if someone commits the act of discrimination, he would go unpunished according to this new law, as the public defender or the ombudsman do not have any punitive mechanism to respond on the act of discrimination. The only mechanism is the recommendations that is not binding, and the discriminator is not obliged to follow with this recommendation issued by the ombudsman. This was the result of this bill, and this bill was sent to the parliament. Leo has already mentioned the drafting process in Moldova, and the scenario was the same in Georgia, as the Orthodox priest, and here's the picture of them, sitting in the parliament. It's a Human Rights Committee hearing, reading of this bill, and they were protesting this law. They do not want to see two words into this law, and these magic words are sexual orientation and gender identity. They strongly requested to erase these two words out of the bill. They said that Parliament intends to legalize the sexual deviation, and this is not in comfort with the Christian values. EU intends to substitute Georgian values with the foreign values and stuff like that. And as Leo has already mentioned, this kind of campaign was orchestrated by Russia, and pro-Russian organization supported this kind of activity, and some of the priests threatened to the members of the parliament to banish them from Georgian Orthodox Church, not to say their name in the praying. So it's a ritual in Georgian Orthodox Church to name someone during the prayer. So they threatened, intimidated to the member of the parliament not to say their words during the prayer. It's some kind of religious sanctions, and they tried to put pressure upon them. But parliament and one man, a very powerful man in Georgia, who used to be our prime minister, was very confident to adopt this law, so no pressure. Although Georgian Orthodox Church is too powerful, omnipotential institution in my country, about 90% believe in church, and this is very powerful institution, and politicians are very reluctant to stand against them. In this case, this pressure, Parliament was resisted to the pressure put upon the Georgian Orthodox Church, and the bill was passed. But civil rights organizations, this is the next picture of us, were not happy with this law because we supported the initiative that the sexual orientation and gender identity should be kept in this law, but we wanted effective mechanism. mechanism that was capable of enforcing this law. We don't want ombudsman that just criticize the alleged discriminator, but it did not bring any outcomes, any effects, any effective effects. This kind of recommendation. However, Parliament also rejected our initiative as well. So we have the Ombudsman with its non-binding recommendation. Let's talk a little bit about the Ombudsman institution and the other institution in charge of implementing this anti-discrimination law. This second institution is a court. Let's get started with the Ombudsman institution. Ombudsman has right to investigate the acts of discrimination, and it has right to gain access with any information that is kept in public entities. So Ombudsman can request this information, and this public entity is obliged to give the Ombudsman this information within 10 days. If the public entity if the public entity does not follow with this requirement, Ombudsman has right to fill the administrative protocol. This is a motion to submit the motion before the court, and court has right to impose fine upon the public entity who did not follow who has not followed the Ombudsman recommendation. So this is about how to obtaining this information. However, private entities is not obliged to cooperate with the Ombudsman. So Ombudsman can ask any information while he's investigating this case, but private entity has right not to react, not to respond, and just ignore the Ombudsman's request. Don't answer, don't send any letters, don't send any answer. This is what our anti-discrimination law says. And it's great obstacles in our legislation and for Ombudsman, incapability of Ombudsman to effectively investigate the acts of discrimination that is committed in private sector. Ombudsman is incapable to investigate this kind of discrimination, and our organization had such a case. So this case is about Aaron Charles. He's a black man living in Georgia. He's a British national. One day he visited McDonald's restaurant, and two white Georgian men did not want to share the same table with a black person, and they asked to keep a distance out of them. So go to another table. This was the request. Of course, Mr. Charles did not obey their request, and one of the Georgian men attacked on him. And the guard of this McDonald's restaurant did not react on this act. So also this guy called to police, and also police did not intervene. In this case, this Aaron Charles applied to the Ombudsman, but Ombudsman was not capable of investigating this case properly, as the McDonald's has no willing to cooperate with the Ombudsman. So Ombudsman had to close the case without any success. So Ombudsman said that I'm incapable of finding any facts of discrimination in this case. So this is one of the effects of this, ineffectiveness of this institution. I want to say another novelties of this law. This is about burden of proof. Who should prove that discrimination takes place? I think this is one of the greatest achievements of Georgian legislation, as the alleged discriminator or defendant is obliged to prove or bore the burden of proof that no discrimination takes place. However, plaintiff should indicate the facts that constitutes reasonable doubt, reasonable suspicion that defendants commit the act of discrimination. What does the reasonable suspicion means? It's very tough questions. And it is a question that was not answered, or according to the court, was not answered by Jehovah's Witnesses. So we had a small town, Zaltubo is the name of this town, in western Georgia. So Jehovah's Witness congregation obtained a construction permit to build their church, or they called them royal buildings. This is the religious building, religious entities for Jehovah's Witnesses, and they obtained this kind of permits from the mayor of the city. But local Orthodox Christian community started to protest against the construction of this building, and mayor forced to revoke its permit, and he gave interview to the local to the newspaper, and he said that this building is about to construct in front of school, and the members of the congregation would adversely affect on this people, on this student, on the minors, and they would not allow them to build such a building in front of the school, and therefore the mayor revoked such a permission. And Jehovah's Witnesses applied to the court, and court said that okay, mayor breached the law, he did not follow the procedures that is prescribed by law, but there were no discrimination, as this kind of statement do not constitute reasonable doubts that discrimination takes place. We also court upheld this complaint, but no discrimination were found. So it's not easy for plaintiff to say that certain act constitutes reasonable doubt that discrimination takes place, and even such a statement, such a discriminatory statement by the public official, according to the approach of Georgian courts, do not constitute this reasonable doubt standard. Did not attain this reasonable doubt standard that is not in conformity, that does not correspond with the case law of the European Court of Human Rights. There were similar case, not similar, but the case when when the mayor of Moscow said that he would not allow, made a press statement that he would not allow gays to conduct the assembly in the street of Moscow, and European Court of Human Rights said that this discriminatory statement creates some doubts that discrimination has taken place against these LGBT groups, but this approach was not taken by the Georgian court, and the reason is unawareness of the European standards on discrimination, and our judge needs to be trained on this standard and on the anti-discrimination law as well. And I think this case is a missed opportunity for Georgian court to use anti-discrimination law effectively. And what we can expect from the court, we can bring action to the court and request eradication of discrimination and receipt of moral and material damage. And how can we calculate the moral damage? It's two ways, because law does not say anything in this regard. Okay, Georgian legislation does not prohibit, or anti-discrimination law does not prohibit hate speech at all. So hate speech is, according to the Georgian legislation, is a protected speech, and no one has right to submit the complaints to the ombudsman office. So we have and case about Georgian national with Armenian ancestry, Armenian origin, who was written to be deported from Georgia for his critical political statement by the employee of state corporation. And this lady or the public employee posted this discriminatory statement on her Facebook page, and this lady, or victim of this hate speech, applied to the Ombudsman institution, and Ombudsman declared this application inadmissible as the Georgian anti-discrimination law did not prohibit hate speech, and hate speech is the part of freedom of expression. I want to say few words about pending and one successful cases. The pending cases is about the Muslim population who lived in Ajara region, Kobuleti, city of Kobuleti. So Muslim congregation decided to open a campus for the Muslim students. And local Christian population were against this intention. First, they inserted the head of the pig on the door of this campus in order to offend the religious feelings of the Muslim population. Then they blocked the entrance of this building and did not allow children to get in. So this campus has not been opened yet, and police did not react on this issue. And our colleague organization, EMC, Educational and Human Rights Educational and Monitoring Center, sent this case to the Batumi City Court, but this court has not rendered its decision. And I want to say a few words about successful cases. One city council, this is Batumi City Council adopts the ordinance, impose higher fees for foreigners to visit Georgian to Batumi Botanic Garden. So foreigners should pay 8 lari, but Georgian nationals should pay 2 laris. My organization applied to the Ombudsman institution, and Ombudsman agreed on us that this is a discrimination and issue the recommendation and asks the Batumi City Council to repeal this ordinance, this discriminatory ordinance, that there is no justification for a different treatment in this case, but we do not know the answer from Batumi City Council. Batumi City Council has right to disregard this recommendation. So this is, I can say a few words about the progress report. The last report on implementation by Georgia, its Visa Liberalization Action Plan, is that to train the public employees and society on anti-discrimination law, on equality and tolerance issues. This is the only recommendation of the EU regarding anti-discrimination policy in Georgia. Thank you for your attention.
Thank you very much for the 2 presentations, and I think we already have a lot of questions, and it was a good introduction of the situation now. My first question, because of my background as well, so the first question I have that, okay, we heard the story, but what are the so-called national minorities in this story in the region, and mainly in the Visegrád countries? When we refer to ethnic minorities, they usually say national minorities. So my question that we looked at the civil society groups even playing the scenario with the government pushing for anti-discrimination. We would say that in countries like Moldova, 21% of the population made of national minorities. Where were they? What was their perspective? Whether they were active, whether they were supportive, whether they participated in this movement? I'm asking both countries what was the perception and what was the level of activity.
Okay, as I have already mentioned, in Georgia we have very important forums for ethnic and religious minorities. This is the Ethnic Minority Council and Religious Minority Council under the umbrella of the Ombudsman Institution of Georgia. So, for example, Georgian Armenians, Azerbaijani population, as well as Greeks, Russians, and other members of ethnic minority, as well as Muslims, Roman Catholics, and other religious organizations are part of this council. And while this anti-discrimination law was drafted by the Ministry of Justice met to this council, and she heard the opinion of the member of this council, and I have already mentioned that this process was transparent, unlike the process that was take place. Oh no, Arno did not agree with me, but I've attended several meetings, and members of religious and ethnic minority was present there. Okay, you can have your comments, but that is what I saw while this law was drafting. I'm talking about the members of this council that is created by the ombudsman, minority and religious minority and ethnic minority council. The process that took place in the government was not very transparent, and the reading of this law was while this law was read in the parliament, members of ethnic and religious minority did not participate in it. It was, only NGOs, civil rights NGOs, were part of this process. And according to the statistics produced by the Ombudsman Institution, about 100 complaints was registered by the Ombudsman Institution, and most of this application deals with discrimination based on political views. It's a suppression of political opposition, and a second is the violation of LGBT rights, and the third is discrimination based on religion, and the number of ethnic and racial discrimination is low. So we can say that ethnic minorities do not often use this law. Even this ineffective law is not often used by the ethnic and religious minority. And this case I've already mentioned, case of the British national who was kicked out of the McDonald's, is the only case of racial discrimination that was ever adjudicated by the Ombudsman Institution. I think the reason is unawareness of this mechanism by the population, and I think this is good recommendation of the EU to increase public knowledge on these issues.
Okay.
Now Arnold has comments regarding transparency.
Yeah. Thank you very much. From what you said, I gathered the fact that basically ethnic minorities or national minorities in the countries were not really the champions of pushing for the anti-discrimination framework. Yeah. I might say that. If it is the case, what do you think? What is the reason for this? Why? You said some political factors for sure, but what would be the reason for this? What do you think?
I think most of religious organizations prefer to use negotiation with the government rather than to resort this anti-discrimination mechanism to complain against the government or other private entities. But there is exception. I can say that Jehovah's Witnesses are very active only this congregation is very active in bringing the case before the court, but this is the only exceptions. Other religious or ethnic minorities, ethnic community try to use the negotiation and mediation mechanism rather than the anti-discrimination mechanism. It is their approach, I think, or we have representative of a community organization from Georgia, and he can just explain why they don't use this kind of mechanism, ombudsman mechanism or the court mechanism. It's the approach and it's a strategy that is taken by this organization. So we can convince them to use this mechanism frequently, and it is a task of the government and civil rights organization to convince them and to encourage them to bringing these cases to the court. So we have a lot of job to do in order to make them active in this regard. I think the bad news is that the opposition politician most frequently use this kind of mechanism in order to blame the government of discrimination based on political views, not the ethnic minorities.
I would like to open and address the question to our colleagues from Ukraine, that whether it was the same situation or is it the same situation regarding the level of involvement of national minorities into the anti-discrimination law drafting, negotiation, and the entire process.
Thanks, Sofia. I will not tell you with the whole story behind anti-discrimination legislation in Ukraine. It was more or less similar to Moldovan and Georgian experience, at least in that part that it was pushed by European Union. And we have to thank for the whole process, for this visa liberalization promise to have the legislation in Ukraine. But unfortunately, no one was involved in the process of drafting because it was not transparent and open. It was Ministry of Justice work overnight. And then it was registered in a parliament without any attempt to discuss this with civil society. It was rather the process of commenting it later after the first law was adopted. And national minority NGOs, well, to a certain extent were involved, not so much religious minorities. But now if you look at the statistic it is provided by a national equality body, which is Ombudsman in Ukraine as well, we see that it's mostly religious complaints that are coming. Out of almost 500 complaints last year, it's 154 complaints on the religious discrimination. Slightly less complaints on ethnic or racial discrimination, and just one complaint coming from LGBT person. We had the same concern and same protests from church and other actors saying that it's not Ukraine and that needs this law, not national or religious minorities, but just these LGBT people, and you're behind them. So I'd say that the main issue is for years, since that's the practice we keep since Soviet Union, we had perception that minorities in a country, what they need are festivals, music and food, and that's it. They've been trained to expect that kind of support from the state. And it was the practice that Ukraine inherited and accomplished for 22 years, just giving money for festivals. I'm not talking about what is minority rights, what is integration process. So people expected this from state and still expect these kinds of support, and many of them do not understand what are minority rights, what to demand. And when they start, they see that the state is not ready to provide it to them. We are not talking about inclusion, we are not talking about integration, we are not talking about representation in the political process. And that's the reason behind not using anti-discrimination legislation. But I will stop here because there are many things around this law in Ukraine, and not just around the law, but the implementation process.
Okay, thank you very much. I think it was quite a straightforward answer to my question. The next question that came to my mind, and I'm going to ask you all, that you said that you reached the basic standard and now you are expecting to move on. So my question would be, what are the next steps you are expecting? You also criticize the EU a bit, saying that they request only public awareness raising and a bit of training for the public officials. So what do you see? What are the next steps in your opinion? But before we go to this question, I would like to ask the Visegrád countries, one of them who are in the room, that when is the moment when you have the basic standard and then you move on and you move forward? So when is the moment? How much time they need to wait for reaching at the point when you are more or less satisfied with the system you have, and more or less you have what you need to have? So give them some promises, or not.
Hello, I'm from a Visegrád country. I'm from the Czech Republic, and I would love to say something very positive, and I would like to talk about all the beautiful steps that we've taken and about our perfectly functioning anti-discrimination legislation. But unfortunately, I would probably conclude that we're in that situation as well. In one word, it's good, and in two words, it's not good. And precisely because we have the same problem, the legislation is not bad, but the implementation is very difficult because there are no reinforcement mechanisms that are really effective. And that's precisely what Gio was talking about, was the no competence of the ombudsperson to enforce the statements that they issue. So that would be the major problem. And the access to justice, that is still a big challenge in our countries as well.
First of all, I'm not criticizing EU for recommending Georgian governments to increase the knowledge of public employees and the general public on anti-discrimination issue. It's very important and crucial thing, but I think it's not enough. Okay, even if the knowledge of public employees were increased and their sensitivity is enhanced on this issue, it would not help those who are being discriminated, because they need effective mechanisms to cure the effects of discrimination, to eradicate this discrimination, but we do not have such an effective mechanism. And I would like that EU would keep pressuring Georgian government to amend this law in order to create effective mechanisms to enhance ombudsman institution, to enhance and to give effective and comprehensive remedy to the court of common jurisdiction. So our expectation from the EU and from the visa liberalization process is to create effective anti-discrimination mechanism. That is all we want from this process.
No, I just wanted to respond to your question, because my colleague from the Czech Republic responded, but and I didn't want at the first instance, because the next presentation is mine, but maybe I should tell something. So I would like to be very optimistic, but I cannot. But I wouldn't say that I'm skeptic. I'm realistic. So Zsófi asked whether the turning point has already arrived, like in Slovakia. So after 10 years of the adoption of the anti-discrimination law in 2004, the turning point has not come yet in Slovakia. But you know, this is some kind of like a chemical process. Who would expect that the island would adopt an act on civil partnerships like 2 years ago, and they did it. So the most Catholic country in Europe. So, but sometimes the last drop in the glass is enough to bring the change. But so that the last drop can come at a time, you have to do a lot of things so that it comes. So that's the only answer that I can give you.
Thank you. Is there any question from you?
I had a question, if there is still time,
Yeah,
because
go ahead.
you both stressed, and I always stress it also, that what's very important in this implementation of anti-discrimination legislation is the scope of the competence of the equality body, that you stressed a lot, that it doesn't have enough competence. Do you have a clear idea what sort of competence should be added to the ones already existing, or how it could work? Because when we were dealing with this in the Czech Republic, I agree with what you're saying in this, we need to broaden the scope. We found out that actually, for example, the right to file actions in the court only has the Norwegian equality body, and they never use it. They don't use it because they perceive it as a conflict of interest. They would not be independent investigators in that case. So do you have an answer to this? Is there a way?
Just one remark, that we have an entire session, 3 on the role of equality bodies,
Okay.
and the value added of this section, that we will have 2 equality body members, one from Moldova and one from Hungary. So it's also an option to discuss in front of them. Maybe they have, but feel free to answer. I don't know who wants to.
First of all, in order for Georgia to success on equality rights, Ombudsman needs effective mechanism regarding private sector. This is the most weak side of our anti-discrimination mechanism. It's very weak point of our ombudsman institution, and I think Georgian law should amend in a way to entitle to entrust the ombudsman some maybe repressive mechanism towards the discriminator, towards those private entities who refrain from cooperating with him. For example, this McDonald's instance, when this restaurant totally disregarded the request of the ombudsman and did not provide any information regarding the instance of discrimination that has been taken place to this restaurant. And I think, first of all, ombudsman should get effective mechanism, and of course, actio popularis mechanism would be better to represent the interest of this mostly affected groups before the court. I think it must be good for our ombudsman institution and useful to combat discrimination.